pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Walter Everett. Here. Steve Bible. Megan Dyson. Here. Mike Pizzolone.
Here.
Robert Howard.
Here.
Elizabeth Rice. Here. Tom Bible.
Here. Do we have a quorum? We have minutes from the December 10th Joint Judicial Committee meeting and February 11th. Move to approve. Motion and a second. Any additions or corrections? All in favor say aye.
Aye.
Any opposed? Motion carries. Old business, we have a flood study for Fairmont. I guess Brian, you're going to handle that?
Yes.
Is it both sets of minutes?
Good morning, Mr. Chairman, members of the committee. There was an RFQ that the department issued for consulting services to do a flood study in the Fairmont neighborhood. We received 18 bids, we ranked those, and we interviewed 6 firms. After that interview, we ranked all of those firms, and we ended up selecting the Ciorba Group. We need to seek approval in a resolution form that will allow the county executive to negotiate the scope of services and sign an agreement with that firm. And that will be in your county board packet this month.
Any comments or questions?
So
Motion. Is there a second? Second. All in favor say aye.
Aye.
Any opposed? Motion carries. Okay, under new business, the first item, case 6157SB, we've been asked to pull that from the agenda. They are considering other sites. So we'll move on to the next case, 6158M, map amendment from E2 to A1. David?
Good morning. And also with regard to case 6157-SV, we will have that on the agenda for next month for either moving forward or status. With regard to case 6158-M, the map amendment from E2 to A1, this is an approximately 40-acre parcel in the northeast corner of South Walsh Road and west of Arsenal Road in Wilton Township. The applicants are requesting again the map amendment from E2 to A1. They intend to record 4 10-acre parcels. This is consistent with the county's LRMP. Staff did recommend approval as well as the commission.
Any comments or questions by committee? There a motion?
Second.
Second. Anybody object to this change? Okay, all in favor say aye.
Aye.
Any opposed? Motion carried. Under other business, building ordinance review. Ray?
I'm sorry, Mr. Chair. Good morning and welcome to you and the members of the Land Use and Development Committee. Our Building Ordinance Subcommittee has met, and through the work of these individuals, these intrepid few, Chairman Weigel, Chairman Weigel, Member Eustace, Members Moran, Howard, and College, we were able to go through the past year and look at upgrading and revising and bringing our building ordinance into the 21st century. In doing this, we had labored long and hard on the 2012 codes, which are embodied in our building ordinance, and had gone along with refinements and revisions, and you will find in your packets, hopefully, the lined out items, as well as a clean copy of the draft that has everything except the one final revision that we have made that was more concisely addressing the Department of Fire Prevention and its duties. That, if Colin would, if you can bring that forward, it'll be the only thing that you don't see currently on your line out section, but is embodied in the code as we're presenting it in draft. What we're asking today is for you, the committee, the parent committee of our subcommittee, to review what we've gone through, what we've lined out, We had a number of things before us, and it seems like it has taken almost more than a year, but we have gone through chapter by chapter. We've reduced the redundancy. We actually have taken the redundancy out of our building ordinance. We have taken various areas that were confused in these past years. We've done something for the first time in Will County. We've made this a part of a very transparent process. We've put the elected body basically into a position where they gave us input, where they continued to take the various comments by their constituents so that we could at least look at that, see what we could do to conform or otherwise address those things, and we put those in. There were various things that we had done that were questions. And one of the first concerns of the subcommittee was why can't anybody just view the codes? You know, we embody the codes in the ordinance, but yet the codes weren't anywhere for people to find other than a library or to spend about $500 on a set of books. And through a process with the ICC, who basically sell the books, we did find a read-only set of codes that they would allow us to publish on our website. So Will County's building website, through the part and the work of the Building Ordinance Review Committee and ourselves, the staff, have now posted every code that is associated with what we do. And we've also, with the very general codes in the front of the book, we talk about the building and the electric and the plumbing. We've instilled a lot of common layman terms into those areas so that it's easily read and easily understood without having to go through the volumes and volumes of code books. Those were things that that the Building Ordinance Review Committee had really worked on and we sought to hammer out. Another thing that we're doing, which is another first for Will County, is actually forming a board of appeal. Today, if it went through the building division, it went to the chief building official, and basically that was the final rule. There was no other place to go. And with adoption of this ordinance with a shall create rather than a may create a board of appeal, we will now have that step that allows those people who are unsatisfied with what we may be saying or have some problem with our interpretation, and they can take it to another level. And these people will be, and there's a recipe to do this, very qualified, very impartial individuals that will sit on a case-by-case basis. So that is another component that we've actually gone into. Before you, you'll have some of the documentation as far as one of the hot buttons for this code was the fact that it embodied 1- and 2-family residential sprinklering, fire suppression. Well, we know what happened to the state fire marshal at the state level, and we know that this code embodies that. That portion, 313, has been struck in its entirety, and that is not going to be enforced by any of the county, and it will not hold up occupancy or permit issuance. We do work with our fire protection districts, which we have 38, but if they choose to go beyond what we enforce with our codes, they will have to do it as the individual fire protection district with that particular entity. So we have case law that's given by Keith Ashelman that you find on your desktop. And the other thing I wanted to hit on was our ISO rating, the insurance service offices. This is another thing that you don't know about because the codes are there, and this office basically looks at every individual municipality as well as counties. We have a checklist, and you'll find that in your packet, to label and to also define each one of our inspectors, our code practices, and what codes we've currently adopted. It's a grading scale from 1 to 10, and the nearest you get to 1, the better it rates with the insurance office. What they do, they're sort of a clearinghouse for all of the various insurance companies that do business within Will County as homeowner insurance providers. They will look at the ability that we have to meet codes, to enforce codes, and how current we are with the codes, so that they know that these homes that we have in Will County, in many ways, surpass many of those that are in the municipalities, thereby making them a better value, also less prone for damage by fire or electrical problems. So they were able to give us our rating. We scored a rating of 4, which is very good, actually, and we're hoping to even increase that a little bit with this. But this is one of the sidebars. When you do have codes, and when you enforce the codes, it doesn't only affect those people who are building, it affects the entire Will County Unincorporated, because it's their insurance that's going to be reduced in a homeowner's fashion by our effectiveness. So that's one of the sidebars. Codes themselves, codes, you have to remember, are minimums. They are the absolute minimum standard, so that we know that this is where you have to start. We know that you can only span so far with this piece of lumber or this engineered piece of lumber. We have to keep current because daily things change. So as long as we keep up with that, we're not only providing the best bang for the buck, let's say, as people in our unincorporated Will County might enjoy, but we're also providing services to the rest of unincorporated Will County in the reduction of their own homeowners insurance. So that's why we do what we do. And today what I've come before you to do is to request you to please review the drafts, the lineouts, the clean draft that we've offered, also taking consideration that this change has occurred. And then I was going to ask to please have the parent committee authorize a public hearing so that we can take this to the public. We've had 2 open listening sessions so far at the Frankfurt Township Hall, and we've had numerous meetings. So what we'd like to do now is finally, at this point, bring that forward and let the public have some formal input, as well as the county board.
Okay, thank you. I'd like to point out on the board here, this is language that Bruce Freifeld had put together to identify that we're not going to be including sprinklers. It also talks about the fire prevention department. It says in the last paragraph or last sentence, the issuance of a county building permit shall not be delayed. I talked to Bruce, and I think we should also add in there occupancy permit, so that we can also issue occupancy permit and not delay a house being built. In reference to the fire department, we've had that in our ordinance for 20 years or more. This is something that the Realtors Association takes dispute with. They don't think it's necessary. We allow that so that the fire departments can do fire inspections. The county does not have to hire fire inspectors to go out and inspect buildings. It's primarily for commercial and industrial. I don't believe that the fire department goes out to a lot of residential buildings to inspect houses or things like that.
Fire protection.
Fire protection, right. The county probably does a majority of that. So it saves the county money. We would have to hire fire inspectors if we deleted that from our ordinance. It's a cooperation between the fire departments. There's 38 different fire departments, and their codes are probably basically the same. But they have their own fire inspectors, and they do the service for the county, and they don't charge us anything to do that. So I think we should continue to have that in our code. So with that, our state's attorney also gave us a letter saying this is, they agree with the approach that we've had so far in this regard concerning not including sprinklers in our ordinance. So I'll open up for questions by the committee. Any questions concerning the ordinance as presented? I think what we'll do is, if we have a discussion today, we'll bring it back for a public hearing next month at our land use meeting, and then we'll vote on it next month at the land use meeting. So, do you have any questions right now?
I think our county board members should have the opportunity to review all of this. I mean, it's a lot to go through, and I mean, let's do it. We took this long, so we might as well finish it, you know, in that manner. Let everybody go through it all, you know, so, because I'd like to go through it again. I mean, it's like reading a dictionary, you know, so I think we should, you know, allow that, so let's not hasten this.
Okay. Do you agree to go with next month then?
Yeah.
Beth?
I agree with that timetable. What do you propose?
Motion?
You mentioned Ray, you mentioned an appeals process. Who would sit on that perceived board or whatever, and who would appoint them, that sort of thing, and how large would it be?
The appointment official is the county's highest level of appointment.
I'm sorry?
Appointments are made by the highest level of the appointing official in the county. In this case, would more than likely be Chairman Walsh. However, each of these people have to meet criteria that is specified within the codes. Have a certain background, have a certain degree, have a certain work knowledge, have a certain amount of management skills, and also design knowledge. Each one of these 5 individuals that would sit in the 2 alternates would have to meet that criteria and be approved ultimately by the county board. But they would be the hearing committee or the appeals board. And if there was a case-by-case basis, and typically what's done is each individual would have $50 per meeting per diem that paid by the person making the appeal. That would be the appeals process. The appeals board would have the final vote and would have the final say in which direction the ultimate decision would go.
And that decision would ultimately come back to the county board?
No, it comes back to the building division as this interpretation. You shall follow this.
You mentioned fire protection districts. With this new language that you have here, will they in any way, shape, or form be able to staff a building permit occupancy or anything that would stop some kind of building that we have on 1 and 2 story or 1 and 2 family buildings?
Well, it basically is all encompassing, not just the 1 and 2 family dwellings. But they are able to enforce their own ordinance, their own rules and requirements. We, by way of this ordinance, are not required to do that. So we can issue the permit, we can issue the occupancy without their consent. However, the homeowner, the business owner, ultimately may be litigated in a form such that the fire protection district, in their own authority, brings that to them.
Well, if that be the case, then it sounds like they could stop something. I mean, you issue a building permit or an occupancy, and then they say, wait a second, guys, you didn't meet our requirement. I don't think that a fire protection district should overrule the county.
They're a separate taxing body who have absolutely no jurisdiction.
Well, this is an unincorporated Will County, so our law should be it.
I would defer to our state's attorney.
The state's attorney has given us an opinion that they can't enforce their own ordinances, but they'd have to go through the court to prove it. So they have their own authority.
Well, it seems like it would be some sort of a bit of confusion. I'm thinking if I want to go build a house or something in unincorporated Will County, I think I'm all set and ready to go, and then some other entity puts the stops to it.
We do advise each and every applicant upon their application, or if it's in a pre-application meeting, or if they call, to contact their local fire protection district and make sure of their requirements. There is only one fire protection district in all of unincorporated Will County that requires sprinkling of 1 and 2 family dwellings. We do advise those people who do apply that this is the case, and before they begin to spend money on design and such, to speak with those fire protection districts to make sure of the requirements that they're going to have to ultimately make.
Well, then it sounds like what you're saying is they can pretty much overrule what we put forward. Mr. Pat, you have
I think it'd be helpful at this point to review what current practice is, what we're doing today. What we're doing today is that as an individual applies for a building permit, they go through the process of submitting their plans to us, and we review them according to the existing building codes. But simultaneously, their application is going out to the relevant fire district, and we instruct them that we cannot issue you the permit. We will not issue you the permit until the fire district has signed off on it. Okay? That's what we do currently. Now, there certainly other members of the review committee who felt strongly on this subject should articulate their point of view better than I can. But as I understand their position, they felt that current practice that we have, where there is in essence, if you choose to call it this, a veto power of the fire district, because we will not issue the permit unless they sign off on it, that this represents a reform or a change where we would not hold up the issuance of our building permit or occupancy permit because it had not received the approval of the fire district. But yet it also recognizes that as a separate political subdivision that is authorized by state statute to enforce certain rules, that they could take any enforcement action they choose to, but it would not put the county in the position of holding up its administrative actions pending a decision of the fire district.
What would happen if I built my house, I've got my building permit, my occupancy permit, and I chose not to follow what the fire protection district said, if there was one?
If the fire district chose to pursue the matter under their ordinances, I'm going to defer to the state's attorney about that particular scenario.
Well, the issue basically does become between the homeowner and the fire protection district. It doesn't pertain to the county at that point. They have the authority to enforce their own ordinances or whatever regulations they may have.
Mr. Adnick, I can tell you that if there had been a conscious design behind the current practice, it was based on trying to be helpful to the consumer, the individual obtaining the permit, who doesn't know the multiple roles that all these jurisdictions play, and trying to have as a single point of contact, a single transaction, a time where all these decisions came together, so that that was the rationale and reason for not issuing our permit until such time as the approval of the fire district had been obtained. That was the reason, to avoid precisely the scenario that you're talking about. But members of the committee felt that that was assigning too much of an inappropriate veto authority to an external agency. But personally, I will have to indicate that I predict difficulties. I predict problems if we go down this path. That precisely the scenario that you're talking about, Mr. Adnick, will occur. And the people that they will blame will be the land use department. They'll say, why in the heck didn't you tell us that we were subject to these fire district rules?
We had that exact discussion in our committee meeting. The problem is only one fire protection district out of all the others actually has that ordinance in there. That was discussed. There was discussed about disclaimers at the bottom of the building permit, et cetera, et cetera. Well, let's look back in time here a little bit. It already exists. If you live in an unincorporated area, if you don't go to the highway commissioner and get a culvert permit, you're not going to get a culvert. So, I mean, at that point in time, the burden shouldn't be on the county to inform every one of all the other taxing bodies. And I don't know if any of the school districts has impact fees or anything like that. But I know in Grundy County, you can't get a building permit unless you pay the impact fee for the school district. So all it was, the statement that was being made is basically there's other taxing bodies out there. The homeowner should be aware of the other taxing bodies. And there is no, again, you go back to the culvert permit, I've never seen it mentioned anywhere. Actually, I built in the unincorporated areas, and basically you just found out, hey, look, I got to go get a culvert permit. You know, maybe some of the other townships do it different out there, whatever, years ago, that's what they did. But again, there are other taxing bodies out there, and we just recognize us as the Will County Building Department that's issuing a permit, and that was the end of the story. And again, it's only one fire protection district out there out of 38, or whatever it is right now. So, you know, I agree with part of what you're saying, and I disagree with part of what you're saying. But I have nothing against being a good neighbor and telling everybody, here's the whole story to begin with. But at the same time, we also recognize we're a separate taxing body.
Mr. Moran, you had a question?
I was just going to state that during our discussions on this, if we did decide that we were going to put a disclaimer at the bottom of the building permit that was going to inform the homeowner and the builder that could be a requirement by the fire protection district that's different. The quandary for us was that we have 38 different fire protection districts, and each one of them can do their own rules, and our code enforcement people would have to learn what each fire protection's rules are and you could have two houses right across the street from each other that are in a different fire protection district, you're both in unincorporated Will County, yet they could be inspected to a completely different standard as far as fire protection goes. We were trying to make it so that our code was one standard.
I disagree with Mr. Paddock. And the reason I disagree is because in these new codes, we've adopted the 2012 fire code with the exception of sprinkling or residential homes. That's the only, so more than half, we've got a stricter code than the majority of the fire protection districts who are in the 2006 code. So when you say, well, you know, we're opening ourselves up, how can we have a fire code in our ordinance that basically is the 2012 code. We have one fire protection district that is requiring sprinkling systems with zero square footage. So that means no matter how big your home is, you're going to do that. That's the Manhattan Fire Protection District. The Village of Manhattan don't enforce it. And I don't know, I actually think that the fire protection district's ability is fairly limited. But if they want to start taking the people to court and then have a judge start issuing court orders on either people come in compliance or get out of their house or whatever a judge would tell them, you know, I think it's pretty remote. So I think that you know, you can always talk about the exception. In our county, we would have one exception currently that would be more restrictive. Most of the fire protection districts are less restrictive. During our process, we asked the fire protection districts to get together and give us a uniform code that we can follow. So we're not applying 38 different fire codes, that we're applying one. And that's what this county should be doing, is applying one. This is the fire code we've adopted. We haven't adopted 38. And I might add, I don't even know how this practice came into place, because there was not one intergovernmental agreement that said we were going to do this. So at some point, I have to assume some staff, and I don't know under what administration, decided to do this. But and it was never in our codes that this is what we were going to do. So I think that in the fire protection districts, they couldn't even come up with something that was uniform amongst themselves. And many of them have no intentions of coming up to 2006 code. So keep in mind, we've adopted a fire code that is almost the highest standard recommended. And if there's a fire protection district that wants to go beyond that, you know, I think when it comes to fire suppression systems, a sprinkling of residential homes, that probably should come to the state. Let the state mandate it so it's uniform across the board. You know, but the state backed off it. The state fire marshal backed off it. As far as notifications and telling people you better go check with your local jurisdictions, they should always be doing that. And by the way, these are builders for the most part. These are not non-con saying, oh, I'm going to do my family project, let me go out and do it. And you know why that's not happening? Because we won't issue a permit. If they want to do it themselves, if it's major. So, unless they become we've eased up on that a little bit. If it's their home, we'll let them make. But the point is we require contractors to do the work. And contractors know the local situations. So, to suggest that somehow somebody's going to come back and go, you should have told me about this, I think it's pretty unlikely, because contractors should know what they're doing. So, I think the subcommittee put a lot of work in this. We discussed this, we beat it around, we kicked it around, and we were pretty much in agreement on everything. We had a lot of discussion about this fire code. We had a lot of discussion on having a uniform fire code for the county that we could apply across all unincorporated Will County, which I think is what we should be doing. And we can't control what a fire protection district might do. We will still continue our partnership with the fire protection districts when it comes to commercial properties. Tom, you made a good point. They don't even, I'd like to know when last time a fire protection district actually inspected a residential home. You know, it would have to be an extraordinary home, maybe, you know, something that's 10,000 square feet or something, maybe. But I doubt if they even inspect them. We inspect them through our own code. If they have, and even if we sprinkled, we would still inspect them. They wouldn't. So I think that we're on the right course here.
Thank you. Mr. Howard. A statement was made today, I just want clarification of it. A homeowner still can do any type of work on his house, correct?
A homeowner in residence can do whatever he wishes to do.
If you go get a building permit, you can do all the work yourself, correct?
They just sign affidavits that they're doing it themselves. That's
Okay,
all.
Jim, you made that statement.
Well, let me say this. We've made homeowners, we may have changed it slightly. We were telling them they had to go get insurance. We were putting an extra burden, and it was making it very difficult for a homeowner to do something. But let me tell you, Bob, you go over and see if you can go help your neighbor. And so you're going to do the work as a friendly neighbor from the church. Can they do it then?
Yes.
Yeah?
As long as no money's
The
paid.
contractor ordinance says a friend, a family member, or a person in residence. We do have a problem because it seems like everyone that comes into the county and buys three or four different foreclosed homes, they're all going to live there, they're going to have their friends help them, and they're going to do all the repairs. Unfortunately, we have to call it at one point or another that you can only live in one or two homes at a time like that. So, you know, we have asked for contractors in some of these cases, so simply because we know that they're not going to live in all of the homes they buy.
Listen, Ray, I get so, you know, I don't want to distract from this, but you're just not being straightforward what we actually do. When I had, a little more than a year ago, somebody come to me who wanted to help his son's in-laws, we wouldn't give him a permit unless he was a contractor, which required him to go get insurance. Now, we may have eased up on that. I know we've eased up on it a little bit more lately, but I will tell you, don't say we were just letting anybody work on homes if it was more than a major job. We were not.
Well, I'm not saying that. I'm just
Well,
saying
I think you did say that.
Okay, if I did, then I misspoke.
Well, that's all I took. So, Bob, let me tell you, you bring that up, and since this is off the subject, but since you brought it up, that is absolutely not the case. That's not what we were doing. You may think that's what we were doing, but it's not. That's not what was happening in reality. Did it ease up when we brought it up? I think it has.
Well, anyway,
I just want to tell you, don't say I misspoke, because I didn't.
All right,
And when you say I misspoke, you better know what you're talking about.
All right,
I'm just telling you.
clarification. So I'm not going to debate you with that. But anyway, all I can say is prior to me being county board, I actually dealt with careful, Mr. Moran. I dealt with the building department, and I did all the work myself. I never had a problem with that. I didn't believe at that time that I was doing anything wrong or whatever. And I just received clarification that I was not. And I did all the work myself. So, you know, again, and I'd like to say that for the record, because a lot of times misconceptions are put out there. But again, I have to compliment the land use department. They're always very helpful to me as a homeowner. When I went in there, you guys all, you know, offered suggestions, that type of stuff like that. So you're very straightforward. So
You must be special. I guess you're special.
I am special.
Yeah, I guess you are.
Mr. Bellet, you have a comment?
Yeah, I want to compliment Mr. Moses for explaining that real well. But I have another problem. Now, the international building codes that we did, we were about, you know, that's the whole idea behind this committee, to adopt those codes. Well, we talked about building green and sprinklers, and that's it. We didn't address any of the other problems. And so when I actually made a motion, or Jim did, and I seconded, I don't remember which way, but to bring it to the full county board through this committee, because we were getting nowhere in that committee. The international codes for 2012 I tried reading it, it's very confusing, and I'm not about to vote on something to create new laws for people without knowing what's in the bill. I've asked legislators from both sides of the aisle about these energy codes and what the implications are from it, and none of them knew the consequences. And so when I say that, we're going to vote to update the 2012 code, and we don't know the consequences. I got a letter from Carl Kimball. He's with the state board that's in charge of these rules, and it says, per our conversation, the Illinois Energy Conservation Code does not apply to residential buildings. Okay? When we look at what we're doing, if you want to replace a window, you have to go get a permit because it was supposed to be part of the energy code. Well, they're telling me that it's not part of the energy code for residential buildings. So we didn't know that. Then a few months ago, it came up that if you had a pool that was 12 inches high, you needed to get a permit and a fence. We didn't know that. I didn't know it. So when we vote for these new rules, there's consequences that all the citizens are going to have to pay. So we got to know what's in the rules. We can't vote on it and have things that are obscure or questionable, because we're voting on something that's going to affect everyone really deeply. So I'm dead against going to the 2012 codes. I'm saying to stay at the 2006, which we already approved. And 2006 does not mandate anything in these sprinklers either. So it's, we got to really think about this.
Thank you. Ray, do you have any?
Well, the only thing I was asking today is that the parent committee, Land Use and Development Committee, would authorize a public hearing. We could have that at some future date to be assigned, and this would allow us to vet all of the public comment as well as county board comment. We have covered much more than just the green building code and sprinklering. The redundancies have been taken out. The 2012 codes parody most of these in many cases. There is just some levels that have come in some language that has been changed. We did that with the lineouts so that you can go back to the codes if you need to. But for the most part, we do adhere to the 2006 codes, and if we want to continue with the new materials that are out, the new installations that are out, we have to go to the code upgrades that actually address those. So that this is what we do. A building code is a living and breathing thing, as well as the ordinance, because nothing stands still. We have sprinkling codes that said if you don't sprinkler, then you're going to have to put drywall on the underside of your joists, wherever this is exposed, so that these TGIs, these engineered joists, don't fail in a fire. Well, the very first thing that happens is something comes out called flak jacket that can coat these, that basically, it's an intumescent, and it flames and builds as there's a fire, and it creates the same kind of burn quality as a solid 2x10 floor joist. So, am I going to expect every board member to know that? No, I'm going to ask for a little faith in your staff. I think the staff in the past 6 years have performed well. I was here 6 years ago at the closing of the 2006 adoption and the 2000 codes. When I'm coming to you now, it's basically, these are the changes, and we're trying to keep up with the industry, and we're also trying to provide some relief for the property owners in Will County in the form of homeowners insurance by keeping their level up. If we stay at the 2006 codes, we are going to fall below a 4. That's going to end up in money, and that's going to cost every person who has homeowners insurance in Will County. There's a lot of it seems confusion regarding the energy law. We have statute that tells us that January 1, 2013, we had to institute this, as well as the radon law as far as June 1, 2013, such that these became something the state told us we had to do. The only other ordinance that we had preceding this was the ADA, which in 1997 became the Illinois Accessibility Code. These are things that we've had to enforce. Now, enforcement can be very subjective. Who has to enforce them? Well, if the state governs a speed limit at a road at a certain level, anybody can basically enforce that. The state may not, but what they've told us, and we're currently being audited by Illinois, as far as the Capital Development Board, for our ability to, number one, have enforced the energy code, reviewed for it, and inspected for it. So that these are things being done by another department that's coming in out of the Will County Building Division to make sure that through our commercial plans review, through our residential plans review, through our inspections, that our inspectors are competent, they have the certifications necessary, as well as our plans examiners, and the fact that in the field it's being done. And we're doing those things so that we're adhering to it. Certainly, if Will County wishes not to, the Homeowners Association said that's great, they still have to do it, or the Home Builders Association said, fine, we still have to do it, because if not, the end user, who is the consumer, the buyer of the home, can sue them in court for those things that they didn't install per energy law.
Mr. Ballant?
And the ISO ratings. I found out that State Farm Insurance is the largest insurer in the United States for homeowners insurance, and they don't go by ISO ratings. They go by homeowners address, and there's as far as like what they're talking about with the ISO ratings, some of that's included, but the majority is based on other items. A lot of it's on their personal finances and other things like that that have no bearing on how far the fire hydrant is from the house. But that does play some part, but not all like we're trying to have portrayed right now. It's just a part, not the main part. And the other thing is, when we're talking about this stuff, we got to be consistent. When we talk about laws that the state says that they will not enforce any of these laws that they pass on us. So we can do whatever we want and they won't enforce it. Well, we're talking about medical marijuana laws, and that's against the federal law. And then when we talk about a building code, we say, oh, we got to enforce the building code, but we don't have to enforce the federal law. We have to enforce the state law, but there's state laws we don't enforce either. So who's the determination of what laws we pick and choose to enforce? We have to look at all that too.
Thank you. I don't have your answers. Any comments by committee?
Do we need a motion to have a public hearing?
Let's have some public comment first. Any public comment concerning this issue? No public comment? Okay. Have a motion to move this forward to public hearing. Let's have it next month at our land use. Motion? Second? All in favor say aye. Any opposed? Motion carries. Thank you.
Thank you.
Mr. Chairman, when would that date be? Do you know when that date would be for
The second Tuesday.
So it'll be the land use committee?
Yes.
For the public comment?
Right.
Thank you.
Next item is certified local government grant. Brian?
Yes, thank you, Mr. Chairman. This is a certified local government grant agreement for rural historic survey of Peatone Township. We were originally approved to make applications a few months back. We were subsequently contacted by the IHPA, which is the State Historic Preservation Agency, stating that additional funding was available. And what you have before you now is an amended grant application and agreement that would allow the county to receive additional funding, which we would use to study Wilton Township. The county has adequate funds in our historic preservation line item to pay for the county match, which is 30%. And this project will continue probably through, it'll get started pretty soon. It'll probably last through sometime summer in 2015. So what I'm seeking from you is approval of this amended application and grant agreement for the county executive to sign and to carry out.
Any comments by committee? Have a motion to approve? Motion? Second. All in favor say aye. Aye. Any opposed? Motion carried. Next item is the marijuana issue. David?
On March 4th, the Will County Planning and Zoning Commission conducted a public hearing regarding the Will County zoning ordinance text amendments to address the public act from the state of Illinois regarding the use of medical cannabis. The commission and the public were verbally provided a brief context of the act and a summary of the associated draft text amendments. There were 4 citizens present at the public hearing and 3 provided comment. Mr. Tom Cronin of Goodbird Greenhouses on Renwick Road presented a proposal in which he intends to use his greenhouse for a cultivation center. He recommended the cultivation centers and dispensing organizations be allowed in the A1 zoning districts. Mr. James Caparelli also spoke on Mr. Cronin's behalf, and he again also as well recommended that the cultivation centers be authorized on agricultural land for the A1 zoning district. There was another individual, Ms. Laverne Wallace, that spoke regarding the cultivation of cannabis. Her main concern was being health issues and to make sure the proper process is followed. In summary of the public hearing, the primary comment was focused upon cultivation centers and allowing them as a special use in the A1 zoning district. I know that our office has had a few phone calls regarding the matter, but no specific comments at the public hearing provided by those individuals. And those comments pertain again to allowing these uses in other zoning districts and for the committee to take that into consideration. So today, what we're asking you is to take into account the public hearing comments that I've advised you of. And if there are any changes that the committee would like to take based upon those public hearing comments or other individuals' comments that are made today, there are 3 options for the committee to take today. Number 1 is to move the board the text amendment as presented, which allows cultivation centers and dispensing organizations as a special use permit in the I-1 zoning district. A second option is to provide direction to the staff on what changes, specific changes the committee would like made to the text amendment, being, does the committee want to expand the possibility of these uses being allowed in other zoning districts as special use permits, which we could bring back to the committee on April 8th with maps showing the specific locations of all the different zoning districts in the county, and then take it to the county board on April 17th. The third option is to provide specific directional changes to the text. Again, that being if the committee desires to expand both uses in other zoning districts today, in which we could still, as staff, logistically make those changes and get those changes to the board this month. So that's what I'd like to see if there's any comments or direction today from the committee. Again, if A, you want to move forward as is, or if there are specific changes to allow these uses in other zoning districts. One primary staff recommendation would be is that if the committee so does desire to change those, is that the uses remain as a special use permit, being that there's dispensaries or expanded into commercial districts, keeping the special uses, or if the cultivation centers are expanded in A1 or the other industrial districts, that they remain special uses.
Okay. Comments by committee? Mr. Howard?
I just have a couple. Maybe you can answer, maybe you can't. Now, my understanding specifically, you're only talking about growing facilities. Dispensary, meaning that there won't be any use on the property, that type of thing. But I just have a question on this, though. Let's say Mr. Jones actually has a greenhouse, and he says, you know what, I'm going to grow medical marijuana. And okay, well, but we're allowing that here, though, correct?
There's only, you can only have 1 license per police district.
Okay, so let's say Mr. Jones gets a license, theoretically. Okay. Now, he gets a license or whatever. Now, what's going to happen? You're going to have a greenhouse with all this.
No, it's not a greenhouse. It's that if you read the statute, the Illinois statute that came down, it's not a field of cannabis being grown, it's not a greenhouse, it's an actual secure building that's
Okay,
24-hour surveillance by the Illinois State Police, and pretty much it's an enclosed, secure building. It actually looks more like a manufacturing industrial building than a greenhouse or...
Yeah, because the name threw me, like Good Earth Greenhouse.
Well, that's just, yeah, and the Illinois state regulations are stronger than any other state that is allowing this right now with security and type of building and all of that. So, yeah, guy with a greenhouse isn't going to be able to get a license, just because he's got a greenhouse.
Okay, so that takes us out of the mix on that. Basically, they're saying this is a facility, all we're doing is say, okay, we allow that facility in the unincorporated area. Okay.
But whether it be a dispensing organization or a cultivation center, the board would make a decision to whether or not they meet the criteria of the zoning laws for a special use and whether or not that use is appropriate for that specific.
Is that still zone A1 though, according to this? You know, and again, these are public commentary. Is that still, they're going to still be able to get an A1 zoning?
As it stands right now, the text amendment is only to authorize dispensing organizations and cultivation centers as special use permits in the I-1 zone.
Oh, okay. So I'm just looking at the public commentary here. Basically, there was a lot of misstatements made in the public commentary.
If the committee wanted to change the text to allow these, or to change the text amendment to allow a special use permit within the A1 district for a cultivation center and they came through the board and received approval, yes, then they could operate that on that A1 property.
Well, I'm just thinking, because to me, technically, it's a business, and, you know, that type of thing, and I think it's probably the value per acre is far greater than growing corn or soybeans or whatever it might be, so I think technically it should be zoned an industrial. You know, I don't think A1, I mean, they would be getting one heck of a deal if they were zoned A1, you know, I mean, so that's why, and again, I'm just going through the public commentary and then looking at that, and basically, there was a lot of misstatements made in public commentary.
A couple things. The state law says what about zoning? Did they make any statement?
The state law allows local jurisdictions to enact resolutions of ordinance to address these particular uses, meaning they can adopt or amend their zoning codes, but they cannot be inconsistent or in conflict with the state law, which we are not in these text amendments.
And so if we do it as special use, when does the applicant come to us? He has to get a special use before he fills out his application.
The state process is not yet complete. I know that there's been draft JCAR rules released, but in a similar process, the state will require the county to sign that they have the appropriate zoning to get the state license or the state authorization to get the state permit. So if the state follows that process, it's conceivable that they have to come to us first to get the zoning for us to sign on the state license.
Which would be interesting, because if we have 10 applicants all coming and wasting our time giving them special use, one can even get it, it may not even be Will County, maybe the other two counties, because there's only one or three counties.
If that's the process and that's indeed the way it would work, I would suggest that would be a business decision for the applicant as to whether they want to expend the funds to go through the process, knowing that even if they receive the zoning entitlement, that they may not get the state license.
That's pretty much how it goes. In order for them to even go to procure that license from the state, they're going to need approval. They're going to need zoning. They're going to need a letter from, you know, whatever village, whatever city, whatever county it is. So they are going to have to have all those requirements before they even try to get that license. So like you said, it is going to be a business license. I just want to make sure that our process doesn't inhibit or create more burden for these people to go get that license. I want to make our process easy for them to be able to use that.
Any other comments by committee? Mr. Patton?
Part of the thinking behind this, and you have to decide as policymakers whether this is a level of control or leverage that you feel is necessary or that you want to have. The whole thing about a special use permit, as you know, is that it allows you to place conditions on the use over and above what was ordinarily required as to use for the underlying zoning. The thought was, and maybe we've misread what the thought was, this is what you all have to decide, is that the desire, given the nature of this particular highly specialized use, was such that the county board would want to retain an extra level of control which you're able to exercise through a special use permit, as opposed to leaving it solely at the level of specifying which districts, zoning districts, it can be used in. So to try to be simple here, you could leave it, you would just say, this type of facility is used in any I-1 by right. But then you would not be able to place any special conditions, which, as you know, you usually put your special conditions on, related to the specifics of the site. Certain unique circumstances, property adjacent that has particular concerns about it, that you then put on hours of operation, or some other element that you feel is necessary to allow that particular specialized use in that area. If you don't feel that the board needs to exercise that additional degree of control over the situation, then you might want to design an ordinance that merely specifies which zones this type of activity is allowed within, and leave it at that.
And another thing which we're trying to balance here is the potential impact on the county and to how much work and changes we make to the ordinance. Under state law, there will be one cultivation center in the state police district, or District 5, which includes all of Will, Grundy, and Kendall counties. The draft JCAR rules identify 3 dispensaries in the entirety of Will County, meaning both unincorporated and incorporated. Now, I believe that other jurisdictions that, whether or not be special use or even permitted use, have gone into such depth of changing their sign regulations and all kinds of other regulations to address these specific uses. And what these text amendments do is to make it simple and leave it as a special use, just to, as Kurt said, as to where you think they may be appropriate, and then through conditions, on site-specific conditions, make any modifications and requirements that may be necessary.
Okay.
Initiated a process to engage all the municipalities within Lake County, engage their GIS department to prepare very detailed GIS maps and layers using municipal data to determine, based upon state law and separation requirements, where things may be able to be located, prepared model ordinances, as well as getting into the level of detail that I described, getting all the way down to recommending signage requirements. We did not do that, number one, based upon the timeline we had, and number two, the potential impact upon the county being very negligible, if any, because of the limited amount of licenses that may be allowed. And quite honestly, we're focusing some of the staff that we have in other matters that may have more impact upon the county.
Okay, and I just wanted to say that I'm supportive of staying on one special use.
Okay.
Just, I know that that's, you're looking for some direction, so that's my personal opinion.
Mr. Howard?
Yeah, I think one danger of this whole thing, though, is that we overthink this thing, because basically the pharmaceutical plant will come in tomorrow. I mean, they have something that everybody, that they feel as if they need security, that they don't want somebody to come in there, take whatever pills they're manufacturing or something like that. So I think it's the same thing. So I mean, at the same time, I don't know what the process here is to compensate that. I think we should treat this just as any other manufacturing facility that would come in, and we should be pro-business on this. I mean, it's strictly another business. And it's a very selective business, you know, as far as a very small window of opportunity at this time. So I don't think as a county that we need to be very careful that if somebody comes in proposing this, because there is revenue involved in this, that we should just address it as such. The security factors, the stipulation of a marijuana growing facility, I don't think should be any different than looking at, you know, someone manufacturing Oxycontins or something like that. So it's the same thing in a sense.
If we limit it to I-1, say somebody has A1 property, we could rezone that property, couldn't we, David, and make it I-1?
You know, they could apply for a map amendment, then we would review it under the zoning ordinance criteria. Now, you know, for instance, though, if it's an A1 piece of property that's out in Wilton Township, and there's no established trend of development in the area, there's no nearby industrial zoning, the LISA scores are high for agricultural productivity and things of that nature, the recommendation from a staff perspective would probably be no for the map amendment. So if you do change it, for instance, to allow this as a special use in I-1, we had reviewed under the special use criteria, you still have the underlying zoning of the A1, and it's possible that they could be approved.
Any other questions? Mike?
Well, I agree with Bob that we can't restrict. I mean, if you look at the paper the other day, Colorado, they realized $2 million in tax dollars in 1 month based on this. This is medical, this is not recreational, that was recreational too. I mean, this is medical, and just like you said, this is just like some pharmaceutical company, we'd be falling all over ourselves to get them in here. And the way this is set up at the state right now, which is more restrictive than any kind of processing facility, if we put special uses on it, odds are Grundy or Kendall have a way better chance of getting a grow facility than we do, because they may not have those restrictions. There's only one for all 3 of those counties that are going to have them. So I think we should have the I-1, not have a special use.
Right.
No, well, I was going to pretty much reiterate what Mike had said. I mean, this, you know, and Bob, you know, this is business. You know, there is possibilities of a revenue sharing with the county, and this is an opportunity that Will County can't miss. And you know, the more restrictions we put on these businesses, they're going to go elsewhere. They're going to go to Grundy. They're going to go. The Illinois State Police District doesn't just encompass Will County, so you know, we have to be mindful of that and not put any more burdens on these businesses and more time constraints and you know, more money for permits and stuff like that. So like I said earlier, I can't put any more restrictions on this.
Sir, you know, last time I pretty much a little conservative on this. First off, I still think that it is a violation of federal law, and I know Reed last time said that they're not going to enforce those laws upon the state. But I'm curious as how this is going to be administered medicinally. How is someone going to be helped? Are they smoking it? How are they? Do you know? Does anyone here know?
I did not review that because that's totally in the purview of the state law.
I'd like to kind of know.
There are strict laws about the prescriptions, the way you have to get prescriptions, when you get your prescription. There's a set amount of the product you can get. It's going to be smoked, they're going to process, liquid, taking the ingredients. So there's no different ways it can be, but it's all based on prescription. So no one's going to be able to walk in. This isn't like Colorado. You can't and buy for recreational use. It'd just be like walking into a pharmacy and getting whatever the doctor's prescription for.
But are they smoking? Are they taking their pill form or what?
Multiple.
You know, and I was told in caucus by one of our members that there were medicinal benefits to this, and you know, perhaps there is. I kind of think that this is the nose of the camel coming into the tent, and pretty soon the camel will be in the tent. And I think this will lead to other things. I mean, we've had for a number of years the issue of smoking and the negative effects of that on various health consequences and none good. And we also had doctors from that industry tell you that it was okay. Of course, they were paid by the smoking industry. With regards to different districts that you're allowed one of these facilities in a state police district. Perhaps you'd like to think of the other counties that would be in that district and perhaps share the revenue so then no one county is harmed and that all would benefit in it and you could do it as a percentage of population or a share of population, something to consider. And I don't have a problem with having if we have an I-1, perhaps there may be a time where we may want to put some sort of restrictions on that or leave that option open. Pretty much covers it.
Yes.
I just wanted to ask about my understanding of special use, because it may be that I misunderstand it. I know a lot of reference to putting more restrictions on. I was thinking with special use allows you to put some restriction on, but doesn't necessarily mandate that it's coming with more restrictions. So if you have a unique property or a unique situation or a really opinionated population, living around it with really strong things, it allows you to put some restrictions. Does it necessarily mandate more restrictions or just give you the flexibility?
The special use process gives the board the discretion as to whether or not they would like to impose conditions on that property. Those conditions have to have a rational nexus, the relationship to mitigate any impacts that use may have. And if those conditions are in place, then it may be appropriate for that use to happen.
Okay, so in my view, it's not necessarily putting a bunch of restrictions on, just allowing you the opportunity to do so if the situation works. I just have a different take on it.
I understand your take. Number one, they're pretty restrictive to begin with. Like, you have to be a half a mile from a residential area to even have one of these. But my problem is with special uses. There's going to be one in these three counties. We have a chance to get one. When this process starts, people are going to start filing their applications. We don't know how fast it's going to go. If we go through the special use process and it takes us a couple of months to come out of committee and vote on it, we may be done already.
I see, so you're more saying that in attracting people, they see special use versus no special use. It's not the special use itself, but what the burden it brings.
Right.
Again, I think we just need to treat it as a business, strictly, and like you said, we bend over backward for a new business to come into our area, so that's, I agree with what you're saying, but at the same time, as Mike was saying, what's going to happen is when they open the gate, they're going to look at it, the counties and a business is going to say, hey, look, who wants me, who doesn't, that type of thing, and I think that's where it's at.
Any other comments by committee? Any comments by the public? Okay, would you come down to the podium? One at a time. State your name and address, please.
Good morning. My name is Tom Cronin. I'm at 20212 Renwick Road in Lockport. And that's the location of the Good Earth Greenhouse Farm. Thanks for allowing me to say hello today. I'll keep my comments focused on the text amendment, which I know is the issue. First of all, I think we should start with what the proposed state law or the state regs are from the Department of Regulation. I have them here, and there is no restriction. And by the way, let me start out. I'm only talking about a cultivation center here. Okay, my comments are only about a cultivation center, not about a dispensary center. My interest, of course, is about the farm in unincorporated Will County on Renwick Road called the Good Earth. I don't have anything really to say, and I haven't studied the question on dispensaries. I know the rules are a lot different for that, just by looking at the regs. So regarding the proposed regs for the cultivation center, there is no restriction whatsoever that it can't be a greenhouse. On the contrary, the greenhouse really is a manufacturing plant. The only difference between what you might think of as a manufacturing plant, like a big building, is whether you're using natural light or whether you're using grow lights. Really, that's the difference we're talking about. And so a greenhouse, like the greenhouses we operate right here in Oncork, Will County, are a manufacturing plant. I was sitting there and thinking, oh, I should introduce my wife, Reagan, is with me today, and she's, of course, a cultivator, and also with me is Colonel Jim Caparelli, who was, as I presented at the public hearing, is handling all the security, or the proposed security for the project that we're trying to pursue here. So first thing is, and regarding the regs, I'm referring, of course, to section 1000.210, cultivation center facility plans and specifications. And there's a whole page of what a cultivation center should have. And of course, all of it is about identification of employers, location of storage areas, location of ventilation systems, location of entrances, exits, location of cameras, fields of view, alarm inputs, everything that a greenhouse growing this product would have and should have. And so the suggestion that it can only be in a kind of what you might typically think of as a manufacturing plant is really not what's required by the statute. And I can tell you that just because I respect what the gentleman said about trying to move fast, and there is some speed to this. This is a 4-year pilot program. In other words, not just 4 years and there's a sunset provision to it. So if people are going to go and pursue this and make investments, and if the county and other government agencies are going to benefit from the anticipated tax revenues here, you got to have somebody who's ready to go. So we have already been down and have retained some folks who are more knowledgeable about Springfield than I am, and I can assure you, represent to you, that not only is a greenhouse not an appropriate thing, it's certainly contemplated in other counties around the state, that using natural light to grow a cultivation center is certainly contemplated and it would be appropriate. And I think it makes sense, most respectfully. You know, we're talking about cultivating. I mean, like I said, a greenhouse is a manufacturing plant. We're talking about capturing natural light to help us. Our carbon footprint is a lot better than somebody who's going to do 24 hours a day grow lights. So in terms of the use of energy and just other uses, why wouldn't you do that? And one of the reasons why we got excited about this product is because what we do now, and it's really not that different. I like the comments who said that this is really not that much different than something else, some other product you might use that has a natural source to it. Right now we grow poinsettias and geraniums and a host of different vegetables. We take those, we grow them, we harvest them, we package them, we deliver them off to market. It's really no different than what's going to be happening with this product. I know there's a lot of energy about this product, and most respectfully, I respect that energy. But in this situation, with the compassionate use of this, what we do is grow a plant, we harvest the plant, we package the plants, and we send them off to the appropriate market. That's what's happening now. All I'm suggesting to you, most respectfully, is that limiting the use of this product, a cultivation center only, to an I-1 district is unnecessarily narrow. There would be no harm to saying it could also be in an A1 district. Of course, it has to follow this inch thick of requirements that has security and cameras and entrances and extras, exits, everything that we have, we certainly anticipate and we understand why. But to say it can't be in an A1 is really kind of limiting Will County's own opportunity here. Because at the end of the day, it's going to be 22 licenses for cultivation centers across the state. 3 counties, right here I think we're in the 5th district, if I recall correctly. So we're in the 5th police district. We want to be ready, able, and willing to go down to Springfield and say that we can competently, securely, and one other promise we've made, of course, is about sharing our revenue above and beyond what the tax structure might be with the county government, so that really all stakeholders can benefit. So basically, what I'm suggesting to you is that our facility, and that means an A1 district, that has the kind of structure that's required, really isn't any different and shouldn't be unnecessarily, eliminated from the possibility, particularly since we're talking about capturing natural light to grow this product, which we think is otherwise a good thing, and that we would pledge to comply with the law, of course, to have all the necessary security provisions and so forth. And I can bend your end of that sometime if you ever care to hear about it. And lastly, that we would be ready, willing, and able to pursue this project if we were so, awarded with the license. I mean, there's going to be lots and lots of people thinking about it. But why not give ourselves, why not give Will County the chance to do this? And for that, I would most respectfully request to allow A1 to be a cultivation facility, and certainly if that implies having a special use permit, a special use process, I certainly would expect to understand that. Limiting it, saying it only should be an industrial district is, in my opinion, most respectfully too narrow and really inhibits you from doing what I think is an opportunity for all of us.
Thank you. We have a question for you.
I have a question. Can we get a copy of that?
Oh, sure. I can, you know what? You can just have this one.
Well, we'll make copies for everyone. But back, because everything kind of like changed a little bit now. So with the A1 now, the revenue and sharing, basically our county, we live off the real estate dollars. You're taxed at a different rate on an I1 than an A1. Now my question is, how are you proposing that? How does that work?
Well, what I would suggest is that we had said that in our papers. That, and again, there's no reason for anybody to be wondering, because this is all new. This is brand new. In fact, the rules that we're all citing is proposed. They have not even been formalized yet. So for all we know, this could change. But basically, if this is the proposed regs from the Department of Agriculture, they're going to have a whole taxing structure. What we're proposing is that an additional, regardless of what else is happening here, that we would take an additional 10% of revenues and donate back to the county. We thought about different ways to structure that, but the idea should be it should be a benefit to all. There should be stakeholders that are all involved in this project. And if you look at some other licensing, process in the state, this could be a very significant, as the gentleman identified, this could be a substantial revenue stream. And my wife and I, we have this farm here. We've been growing vegetables and flowers for a long time. This is a 3-generation family farm in Will County. This was an opportunity. I respect the moral challenge about it. I've thought long and hard about it. And we have children. We have 10 children. So we think very hard about it. And I have teenagers. So I think long and hard about those kinds of issues. However, I've talked to the gentleman, Mr. Lang, who prepared this statute, and it really is the most rigorous and the stringent statute maybe in the whole country. And it's really about compassionate use. And if like I'm sure everybody has, but if you've ever seen someone suffering, you think to yourself, how can you deny them the opportunity to live that?
I understand the use of it. Does it cover the security in there?
Oh yeah, very much so.
Because here I'll be kind of blunt with you.
Sure, please.
Basically, what's happening is here, I don't want some kid to have a pocket knife. And he's between a 6mm piece of plastic and a happy time, whatever. And then that's my concern.
Chairman, could I give you just some information about what we've been talking about? Would that be permissible? This is a little, very brief package just introducing us to the Will County folks, and I believe the same thing we've had before. And basically what we've done in this is we've mocked exactly what's going on and what's the most secure facility you can think of in this whole state, O'Hare Airport. And that's an open facility. You talk about security there. So what we did was we talked to the folks there, and we essentially have mirrored the kind of, and I do include you, kind of steel palisade fencing that would be around there. Colonel Caporelli is retired from the United States Army, and he's come aboard with us simply to handle security specifically. And if the committee's so inclined, I'd ask Mr. Caporelli to address it. But basically, he comes from Gitmo in Cuba. Security is more than just bricks and mortar and building. It's active security. You're talking about the vetting of employees. You're talking about drug testing of employees. You're talking about 24 hours manned security, plus with cameras to make sure you know not just every person who goes in and out of the facility, but every item that goes in and out of the facility. That's the kind of security we're talking about. And frankly, that's the kind of security that Lou Lang, I think, contemplated when he wrote the statute, and the Department of Agriculture identifies here. Because if you look at the security provisions for cultivation center, they say they want to see, a location of all cameras, what's the field of view, a location of all alarm inputs, where are the digital video recorders, all the restricted areas, where are all the employers that are non-production. So this all has to be mapped, and you have to presume, I hate to presume that when you're talking about your team of employees, but there is a certain kind of draconian thing where you got to presume everybody's walking in trying to steal something. So you have to look and act like you're the security at the tollway or the security at the O'Hare. And I respect that, and that's precisely what we're going to deliver.
So at the end of the day, you're interested in coming to Will County with this?
We're here in Will County. I'm interested in having our Will County farm applying for a application for a cultivation center with the State Department of Agriculture.
If you receive the license?
If we receive a license, we would do it. And what I'm suggesting to you is this text amendment would prevent us from doing it if it's only in I-1, because we're not an I-1 district at this point.
Okay, thank you very much.
Thanks for your time.
Anyone else want to speak? Would you come down, please? State your name and address, please.
Name is Tim McGraw, address 15450 Nolan Court, Homer Glen. I'd like to reiterate a lot of what the fine gentleman just said. First off, this is HB 01. This is the law, 200-something pages. Then the rules released by JCAR on behalf of the Department of Agriculture. Well, the rules for the Department of Agriculture concerning cultivation centers are about 80 pages long. Security-wise, every square inch of the facility will be monitored by Illinois State Police via the internet. They're requiring RFID badges, biometrics to enter different parts of the grow facility. So security is well accounted for in the law and in the rules. So the concern of being able to break into a greenhouse because it's plastic or whatever, I wouldn't be that concerned about. There'll be panic buttons in there. I'm not sure about his facility. We'll have off-duty police at our facility when there's no one there. So I would support his assertion that A1 should be an allowable use, but for a different reason. The timeline here is what I see as the biggest factor. If there's a special use overlay and zoning overlays on top of what the state's already put out there, Will County's not going to get a cultivation center. I've spoken with Bob Morgan and Lou Lang on this issue, and they both told me, be prepared to apply August 1st. So that means we need to have all this stuff done far prior to that. Our facility is going to be an $8 million facility, 75,000 square feet. That's a huge undertaking. I mean, from zoning requirements and special use, that's a big risk. That's a lot of engineering. That's a lot of architecture that we're going to dump into this project. And quite frankly, if it stays as restrictive as it is, special use I-1 only, you're going to push away most of the competition. It'll be relegated to only guys that already own industrial property that's 2,500 feet from everything. That's what you're going to end up with. And there isn't any of that in unincorporated Will County. It just doesn't exist. For our plan to build the type of site that we're going to build, we're going to be buying 10 to 30 acres. And under these proposed rules, we'd have to rezone it to I-1, and then on top of that, go through the special use permitting process, which I don't see that we could get that done, know that by the time we're going to apply, that's resolved. And that's going to be the issue, which is going to force us to another municipality or another county that's more receptive, but quite frankly. We do have plans for a revenue share agreement, as they do. So this will bring quite a bit of money revenue to Will County. So I would suggest that the more restrictive that the board makes it, the less likely you are to win a cultivation license.
Do we have questions?
Now, you're strictly growing too, you're not dispensary?
We might, the barrier to entry for a cultivation center is far higher than that of a dispensary. A dispensary is almost an afterthought in this process because the barrier to entry is so low. You only need $400,000. When you're talking $10 million per site, we're applying for a dispensary, we are going to apply for some, but we have, right now our focus is on cultivation because this is the biggest, by far the biggest investment.
In the revenue sharing, is there any obstacles to that? I know we have attorneys on board. I mean, that's something that we can actually do.
We've actually drawn going up for approval.
So basically, as a committee member, the trade-off would be, okay, we're going to get the A1 zoning, but we tend to possibly could make more with the revenue sharing scenario by the daily. So
Yeah, if you're concerned about tax revenue from real estate taxes and not getting enough, and then the farmer tax, obviously, there's not a lot of in there, yeah, that's where the revenue sharing would come in. And that could be written any way you like it. I mean, it could be 5%, 10% of net gross. I mean, revenue share agreements can be written any which way. But yeah, you would be passing up potentially on quite a bit of revenue by narrowing or restricting the uses.
Thank you.
And isn't it correct under the statute that it's going to require these cultivation centers to also provide revenue that is restricted to go towards drug education in the
Correct.
county?
We have to supply to the state in our application. Again, our application probably is going to end up being about 600 or 700 pages long. Our employee training manual is 200 pages long. Our security plan is over 100 pages long. Our operations plan is a couple hundred pages long. So the amount of due diligence and intellectual property that we have to provide to the state is the highest. I mean, we might as well be opening up a nuclear test site. I mean, it's really, the barrier to entry is that high. Illinois is by far the most restrictive state of the 20 that has licensed medical marijuana. They've taken all the most restrictive rules from all the rest of the states and combined them into HB 01 and then the regs. So, and on top of that, we have to put up a $2 million bond, which is a performance surety bond, which is dollar for dollar, essentially, which means we're going to have to put up an additional $2 million just so the state can yank it if we don't perform. So the groups that end up winning these licenses are going to be very cognizant of the rules and the security, and because they're going to have a huge investment into it. Huge investment.
You mentioned dollars and the profitableness of this. What potential dollars do you see that you'd be raising? Any idea?
It's hard to say. We're going to be scaling. In our particular case, on a 75,000 square foot facility, that can grow about 7,000 pounds of marijuana a year at a wholesale price of $2,500 a pound. Just do the math on it real quick, but it's tens of millions of dollars in revenue. So whatever that revenue share agreement is, that's a big chunk.
Reagan, the revenue sharing agreement, is that part of the state statute? That they have to do that?
No, it's not. That's an option outside.
Is there any
There is a requirement, like I had said, there is a requirement that wherever this facility is that the statute is requiring that wherever this place is, cultivation center is located, is that they do provide revenue. That revenue is directed towards drug education, which obviously is something very important, something near and dear to Will County's hearts, because we do have obviously a drug issue, a heroin epidemic. So I think that would be very, very instrumental in getting one of these facilities here.
I have a question. Now, if let's say we just zoned it A1, all right, we said, okay, that's fine. Now, the revenue and sharing, how do we actually secure that, where that's part of the agreement to give the permit to go ahead and do this? What's the catch here? I mean, what?
Essentially, the way it stands right now is my group, the other gentleman's group, will be offering it up to the state. I think it'd be hard to force that because our agreements could be completely different or how they work. I mean, it'd be tough, especially with the timeline presented right now, to add that at this point. I would just count on the fact that if somebody wants to win a license, they're going to have to show that they're giving back.
Okay.
That's in the law, that they're giving.
And I would say, we're not going to be in control of who gets the license. I mean, if we say you can be in A1 and 5 people apply for the license, the state's going to decide who gets that license. It may be in Will County, maybe in Grundy County. So we're kind of hoping and expecting that whoever does get that license is going to do
amongst the other counties.
Right.
And one other statement I'd like to make as far as the medicinal uses, I mean, we are the 20th state to now allow this. I mean, as far as the medicinal qualities of marijuana, I'd ask you to just do a little bit of research. So check out Charlotte's Web or check out any of these other CBD high marijuana strains that are literally saving little kids' lives. Now in Illinois, it can't be prescribed to kids, but the medicinal use of marijuana is very, very, very well documented. And in fact, nobody in the history of mankind has ever died from the use of marijuana. there's not one approval case of an overdose of marijuana.
Thank you. Anybody else from the department? State your name and address, please.
Good morning, Mr. Chairman. Michael Hanson, attorneys, Joliet, 735 Essington Road. First of all, I represent a property owner in Will County who currently has I-3 zoning, who's been contacted by a possible applicant for a cultivation center. So the reason I'm here for you today, basically somewhat reiterating what the prior two gentlemen said. I think in order for Will County to be pro-business and also to abide by your standards as county board members to do what's best for the county, I would recommend that maybe an expansion of the proposed text amendment would be the best interest of the county. In other words, to focus just first of all on my specific situation. My property is zoned I-3, and if in fact a lease was structured and an arrangement was set up where the tenant would want to apply for a cultivation center license, as was stated earlier, the state will decide that on objective criteria. And of course, there may be many applicants from Will County who have the proper zoning, and I think Will County would like to get one. Then in my situation, we'd have to downzone our property to I-1. And then of course, if in fact we don't even, if our tenant doesn't get the specific license from the state, then our property is automatically then zoned I-1. Assuming, and with respect to a special use, if I can digress for just a second, that's really up to the county board. I can see both positions on a special use. Yes, the special use does allow the county board to put special criteria on something like this that you may want to do. On the other hand, with the tight timeline that is being discussed, and the other in the situation where I think you want to abide by the statute and get the license, that may be a permitted use. If you look at your current ordinance right now, for example, Mr. Cronin, who apparently has A1 zone property and has a greenhouse, that's a permitted use under A1. Now, interestingly enough, a greenhouse is a permitted use under I3, as well as I1 and I2. And I would submit to the board, to this committee, when you review your current ordinance right now, and I've done this, that there are some uses in addition to a greenhouse, at least in my specific situation. And I'll list a couple of them right now: soil storage, recycling, let's see, there's another one here, animal feed preparation, etc., that are in an I3 classification. At least they're special uses. And all of this would mean that, at least for your I2, and I guess I'm arguing also for I2 as well as I3, you wouldn't need to change the zoning in order to have a cultivation center. And it would seem like making it wide and broad would be the best interest for the county in its attempt to make any applicant, and like was mentioned earlier, the state will decide this on real objective, strict criteria who gets the license. Because the other question that I've raised with the county staff is, who knows how many people are going to apply for this license? Maybe everybody comes before the county board, goes through a rezoning classification, the county board decides to rezone it, grant a special use, whatever, and nobody gets a license, or one, and then they may have zoning that you may not want, or they may not want, or whatever. What do you do about that situation? So it appears to me, rather than have to address that situation and rezone someone's property, or maybe have zoning contingent on whether or not they get a license, that to make it very broad and open it up to probably not only I2 and I3, because I also think this use, the cultivation center, follows with that criteria. A1, make it very broad. I don't think you're going to do it in commercial. Obviously, they already have in the state the restriction on the residential restriction, which really limits the particular sites in the county. And so that's my recommendation to this committee and to the county board, that really open that up and make it, follow the criteria, follow the rules. I think the staff's done a real good job of trying to set the text amendment, what they're doing, and just open it up, because I think it fits along with what you've done with other classifications.
Thank you. Any questions?
Oh, no, I'm sorry.
I-1, I-2, and I-3.
Okay, so maybe we need a motion to make it permitted use in all those districts.
Second.
We have a motion and a second. Any discussion?
Specifics of the motion.
This would be permitted
Permitted
use
in A1, I-1, I-2, and I-3.
for cultivation and dispensing. Just cultivation.
Before we vote
Cultivation,
on
yes.
this, it would be cultivation for sure, but then there was someone that is in a A1 area that might have the ability for dispensing. I don't think we should limit that.
Well, we can go back and address that. We'll do the cultivation first, and then we'll make another motion for dispensing.
Okay, well, I think it should be open to the business, that they have that option of, that if they do come to us, let's say they do get the license, and they come to us, and we don't want to block them out if they actually want to do cultivation and dispensing.
Well, it's still going to be two separate licenses, so really, even if the same person is applying, it's totally separate licenses.
But we want that ability to grant that in that A1 zone.
Okay.
I would think so.
Yeah.
They probably won't go there because they're going to populations.
Okay, so the motion is for cultivation centers to allow permitted use in A1, I1, I2, and I3. Okay. All in favor say aye.
Aye.
Any opposed? Motion carried. Okay, for dispensing centers, you want it in all those districts also? Okay,
I'll make the motion.
we have a motion and a second for permitted use in A1, I1, I2, and I3.
Mr. Chairman?
Yes.
Was there any consideration to want to be given to commercial districts, or just want to keep it consistent with the I districts and the?
Commercial though for the dispensary probably should be in commercial because it's going to be where the population's at. They still have restrictions as far as they have to be 1,000 feet from schools or whatever other daycare centers. But like a pharmacy, you're going to have them generally in a commercial district. So you're right. So we should add that.
Okay. Which commercial, all of it, commercial?
Just real quick, let me run through the commercial districts for you, so you have an idea. The C1 is local commercial. C2 is some of the local. C3 is more intensive general. C4 is highway, primarily on highway. C5 is to allow commercial within business parks. And then C6 is recreation commercial, which is motor sports, racetracks, and things of that nature. If the committee was looking for a recommendation, if you were to consider it a commercial district, I would probably recommend C3 and 4, and if you want to go down to even lesser, at most a C2. But C1 through C4 would be the districts you want to take into consideration. Again, keeping in mind C1 is the least intense, C4 is the more intense commercial.
Yeah, C1 through 4.
Okay, so we'll say
Still has to meet these restrictions.
a permitted use in C1 through C4. Right.
Yeah, well, no, my second Mike's.
Okay, we have a motion and a second. All in favor say aye.
Aye.
Any opposed? Motion carried. Okay, then this will go to county board then next week?
If the committee desires it to go to the board, we will make arrangements to have it at this point.
Yeah, we'll move it to the county board next week. So our business, as far as comments, we had a statute of limitations discussion with the joint committee with judicial last month. We didn't have time staff to handle this month, and we're going to try to bring it back next month. Kurt, I understand you've had some changes in your staff and reorganization. Could you give us a brief overview of that?
Well, I guess perhaps you're referring to Michael Smetana is now functioning as the manager of our code enforcement area.
About Elizabeth, does she have a new position?
Elizabeth has gone to replace Michelle in our community development division, handling administrative aspects related to a couple of our federal grant programs.
Okay. Any other comments? comments by committee? A motion to adjourn? Motion second, all in favor say aye.
Aye.